Today on Let's Talk Estate Planning, rather than drilling down on one specific topic for the entire episode, I've got 10 questions here. Some were submitted by folks that have enjoyed the podcast. Some are submitted by folks at workshops that I do. Some have come up in client meetings. Some are just people bothering me at parties and family members. Nobody's bothered me. But anyway, these questions, we got down to a list of 10. Why 10? Well, 10 seems like a good round number. And we're just going to tick these off today and go through these frequently asked questions. If you are interested in estate planning, meaning planning so that your family gets along better as transitions occur in life, you're in the right place. This is Let's Talk Estate Planning. My name is Jim Miskell, and I've been practicing law for more than 30 years in the state of Georgia. I've been doing nothing but estate planning, probate, elder law, trust administration, and estate administration since about 2011. My dream is that everybody gets their estate planning done so that as transitions occur, families get along better. Estate planning can't make unhappy families happy, but estate planning can round off and smooth out some friction points so that families don't become more unhappy as grief and crisis occurs. Why? Because those are stressful times for folks in the family, and if we can make the administration easier, one, folks will know what to do, won't have to wonder, and won't waste a lot of money running around trying to figure out how to do administrative stuff, but also they're less likely to get into conflicts with one another. So, having said that, let me say this. What's in the podcast is for informational, educational, and entertainment purposes. It is not legal advice. Legal advice happens when you create a relationship with an attorney and you sit down and that attorney gets to ask you a bunch of questions. Because what you think is important is probably important, but there may be some other things that the attorney needs to know to make sure that what's important to you doesn't trip up some provision of the law that's specific to the state that you live in or the situation that you're in. So, just taking a DIY approach, getting information from Google, from podcasts, those sorts of things, it can be useful to get your knowledge base going, to get a context and a vocabulary, but it is not legal advice. Seeking legal advice is when you hire an attorney and they sit down and they ask you questions and give you advice specifically about your situation. That's not what this is. This is a podcast. So that's my disclaimer. I'm a lawyer, got to have a disclaimer. Let's get to the questions. Number one, my mom did a will. Why do you keep saying probate? I get this all the time, and I had just a couple weeks ago, a client was in, mom had passed away, and they'd come to see what the next steps were. And they knew that mom had done, and she didn't work with us, but worked with another attorney some years ago, and had taken time to do a will. And so the family was glad of that. But they were also sure that because mom had done the will, they didn't have to go through probate. And the fact that I kept saying probate puzzled them and frustrated them. And the son said, "Why do you keep saying probate? Mom did a will. We avoid probate, right?" Wrong. So a will, before the executor has the authority to carry it out, has to go through that probate process. And probate and proof come from the same root word. Probate means to prove through this court process that a will is valid. What does that mean? It means that it's got the right number of witnesses, it was executed properly, that there's nothing wrong with it. And that process involves notifying the family members, getting their agreement if possible, so you don't have to have a bunch of hearings, submitting it to the court. If everything's in order, it usually takes about 30 to 45 days. But a will, rather than avoiding probate, requires probate. Because remember, a will, although you name an executor, you're actually nominating that executor rather than appointing that executor. You have to get an appointment from the court before the executor can act. So that's number one. Wills avoid probate, don't they? No, actually wills require probate. Number two, how much money do I have to have before I think about doing a revocable living trust? Or, and I get this question a lot, how large an estate before trust planning is appropriate? Usually the size of the estate is not the question. The estate tax threshold right now, after the big beautiful bill, is about $15 million per person. $30 million for a couple. Most folks don't have money concerns, or estate tax concerns rather, with the size of the estate. There is particularized trust planning when you're worried about estate tax efficiency, and there are great mechanisms out there for that. Most people ask me this question, how large does an estate have to be? They're not worried about estate taxes. They just want to make sure that everything goes easy for the family. So rather than asking how large does an estate need to be, the question is, what are your assets? What's going on in your family? Would you prefer to have a plan that avoids probate, that is self-activating rather than a will that has to go through probate? Back to question one, a will that has to go through probate before your person has the authority to do what they need to do. And that's what usually governs the decision to go with a revocable living trust. Money-wise, revocable living trust plans that I see are generally less expensive beginning to end than a will plan, because will plans have that probate at the end, and that could be an uncontrolled cost. You're not sure what it's going to be. With the trust plan, you have to do more work up front. It costs more to get one in place, but you avoid that mystery administration later. There are certain things you look for in estates and assets as to whether or not a trust is clearly a good idea. One of those is if you've got real estate in multiple states. If you use a will, that requires probate proceedings in all the states where the real estate is. With a trust, it's all in there, no probate in any state. That's something. Also, if you've got family that just doesn't get along, if they like to wrestle over things and argue about it, and you think that'll slow down the process, a trust is better than a will because it gives them fewer opportunities to stick a spoke in and slow things down. So it's not a question of how large the estate is. It's a question of how do you want the administration to go. That includes, there's better disability protection with a revocable living trust plan. If drafted correctly, you put your disability plans and protections inside the trust, and rather than the family having to run to the courthouse, if you start sending money to scammers, there's a way to contain that inside the plan. So how much money, how large does an estate have to be? Usually that's not the right question. The question is, do you prefer the smoothness of a revocable living trust over the administrative requirements of a will plan? Both can get you where you want to go. One might be a better fit for your family. And that brings me to number 3. I jumped ahead. And what are some indicators that a revocable living trust might be better? That's property in another state. You've got family members that don't get along. There is a history of dementia in the family. You feel like you want to make sure that you're doing a better job protecting your family from your own potential disability. Another one is blended families, where there are stepmothers and stepfathers. You want to make provisions for that current spouse, but without cutting kids out. And that's where a revocable living trust plan with some couples planning in it can make sure that the provisions that are important to both of you while you're here continue to be important going on in the future. And that's not true just for blended families, but it also can be true in first marriage situations as well. If there's a desire that you protect the estate from the remarriage of a surviving spouse, you can put those sorts of provisions in. Trust plans have an edge over will plans because, of course, you can redo your will anytime you want to. When you do a trust with somebody else, you can lock down the provisions. Say, once one of us dies, here are the things that we agree will not change. So that covers the indicators when a trust plan might be better than a will plan. 4, can I just do this myself? I see these platforms on, and the platforms even say these documents, here, come a little closer. These documents are designed by an attorney. They ought to be fine, right? I can just answer the questions. What do you think I'm going to say? I'm an attorney. Here's the thing. Those documents are designed by an attorney who's never met you, never sat down with you, hasn't been able to ask you those questions. I talk about this all the time. Legal advice comes from when you're sitting across a desk with an attorney who can ask you questions. And why is the attorney asking questions? Because they know the law, and they know that there are some potholes in there, there are some tripwires that if you're not aware of them, things can go differently than you expect them to go, than you want them to go. So that's the real Achilles heel of the DIY platforms. And whether that's, a will in a box that you might get in an office supply store or from Amazon, whether you might find it in a bookstore, Barnes & Noble, something like that, or whether it's one of these larger platforms. One of the things you will notice and that you should really take to heart is that all of these DIY solutions have a disclaimer in them somewhere. And the disclaimer reads something along the lines of, doityourselfwill.com is not a law firm and is not a substitute for the advice of an attorney. And I've seen this in the will in the box. I've seen this in the forms available in bookstores. I've seen this on the platforms. That's in there. That disclaimer's in there because it's true. It's at the bottom. It might be in small print, like a lawyer put it there in small print deliberately, but you should really pay attention to that. On that, trust them 100%. Using one of these DIY platforms is not a good substitute for the advice of an attorney. And they even tell you that. So that's it. Designed by an attorney should be okay, right? What could go wrong? Why do I have so many episodes of the podcast? That's what could go wrong. Number 5, I love this question. I get this one a lot. Okay, mom died or dad died or Aunt Edna died, and the family wants to know, when is the reading of the will? I love this. There is no reading of the will. This isn't an Agatha Christie movie. That's not a thing. Now, I'm happy to have a family meeting and we can go over the will. We can do a reading of the will. But in fiction, there's been this thing created like, there has to be the reading of the will. If you're gathered here together, it's because I've passed away and I want you to know these things. We can have a family meeting like that. I've had clients that have created a video for the family to watch, but that's a different thing than the reading of the will as a necessary step toward the execution or the carrying out of the will. It is true, though, that if it is a will and it's going to be probated to be carried out, that involves notifying family members, they're called heirs in the code, notifying heirs of what's in the will. So in a sense, there is a reading of the will, but everybody's reading it to themselves usually. They all get a copy of it. A lot of folks prefer to avoid this with a trust plan because maybe you don't want the kids to get to go, yeah, I like that or I don't like that. Maybe they shouldn't get to pass on it. That's where a trust plan is a better plan. But there's no formal reading of the will where we all get together in a dark paneled room and where it's very tense and then the detective comes in and says, it was you. No, it just doesn't happen that way. But this relates to some of the other questions that we had earlier. Why on earth would anyone do an irrevocable trust? So that's the question. Why on earth would anyone do an irrevocable trust? The revocable trust I get sounds very flexible. It gives a lot of administrative advantages. Irrevocable, that sounds permanent. Nobody likes the idea of irrevocable trust. Nobody likes the idea of things you can't take back. Why would I lock myself in? Well, irrevocable trusts can be fantastic mechanisms, but it's in the name. It's permanent. And so you would only want to do an irrevocable trust if the advantages it gives outweigh what you're giving up, the flexibility that you're giving up. All irrevocable trusts have one thing in common, and that is that what I've put in my irrevocable trust cannot come out to me or for my benefit. That's the thing that's irrevocable. It's a one-way ticket. My access to that asset goes in. Now, depending on the reason for which you need the trust, you may or may not lose all control of the asset. What I mean by that is there is conceivably an irrevocable trust that you might build for asset protection, future Medicaid qualification, any number of reasons, where the asset goes in, it cannot come back out to you, but you maintain control of how that asset is invested and managed. So you lose access but maintain control. When we're talking about irrevocable trust for tax savings purposes, the IRS scrutinizes more closely and doesn't like the idea that folks have control of an asset. That still sounds like ownership. And those levels of control often are not appropriate for a tax management or tax saving or tax efficiency trust. So irrevocable trust, you'd never put everything you've got in that because you need assets to live on. I tell folks very often as they're thinking about it, in a very basic situation, you'd never put anything in an irrevocable trust you think you're going to spend on yourself. If it's something that will be part of your legacy, part of your inheritance, no problem putting it in there. If it's the type of trust where you may have some continuing control of the property, no harm in putting it over there if you know you're never going to need to spend it on yourself. But irrevocable trust drafting, there's a lot of considerations involved. And so there's no easy answer that, yes, this is the kind of irrevocable trust you need or that. But to answer the question of why on earth would you do that, it doesn't sound like something you want. For most people, it's not a desirable situation. If you need the advantages it gives you, it's worth the sacrifices of making one. Hey, Jim Miskell here. Sorry to interrupt the episode. Hope you're enjoying today's content. A lot of times when folks are thinking about this kind of thing, questions spring to mind. If you have questions, we like to do some question and answer episodes. So you can go to our website, letstalkestateplanning.com, and shoot us a message and say, hey, on the podcast, I'd like Jim to cover this on the next question and answer session. Or if it's hitting closer home, especially if you're a Georgia resident, of course, we can't give legal advice on the podcast because it's not specific for your situation. But if you got a situation that you need to handle, it's important to get that done. So letstalkestateplanning.com is how to contact the office. I'd love to talk with you about the specifics of your situation and make sure your estate plan is everything that your family should have it be. In the meantime, we're going to go back to the episode. Thanks for tuning in, and I hope to talk to you soon. Next question. Isn't your work depressing? All you do every day, Jim, is meet with people and talk about disability and death and planning for those things. So if I were to concentrate on just those aspects of my job, it could be depressing. It could be depressing to a lot of people, and I guess different people also have different tolerances. What I think about when I think about my work is not disability and death, because that's something that all of us share. That's going to come, death is going to come to all of us. Disability is going to come to very many of us. And I don't feel like I'm talking about that all day. I talk about the opportunity you've got through planning to make those situations easier for your family. That's the uplifting part of my job. And it's very rewarding when families have gone through crisis, even when one of my clients has died, somebody that I've had a relationship with that family, with that person for a number of years. They've passed away. It's very gratifying when I hear back from the family, when I meet with family members for next steps. And I can be in a room and say, I was there when your dad told me, your mom told me, these are the objectives for the plan. This is how I want it to go. And to see it play out is really gratifying. And it's really important to families. And among the most important documents that we work on are the healthcare directives. And I get a lot of feedback later from families saying that as things got tough medically, it was a blessing not to have to guess because mom or dad had made their decisions clear. And we had that to go by. And we didn't have to fight over it, because that's when fights occur, because people are uncertain. And the planning just gives folks certainty, and it makes things so much easier. So no, my work isn't depressing. Sometimes we lose clients, and that's hard. But the uplifting part is that everybody's got to go sometime, and we know that these folks did planning, so their family had a lot less of a struggle with things that don't really matter when you're grieving. That's the time for families to spend time together, not to worry about administrative stuff. So no, my work is not depressing. Can you just set up the estate plan so everybody gets along? Because my family, they fight, and I'm worried about that. Can't you just set it up so they get along? You know, my kids always argue and this. And no, estate planning can't do that. Estate planning can't make an unhappy family happier. What estate planning well done can do is eliminate friction points so that as tough times come up, families don't have more opportunities for conflict. I was in a question and answer panel a couple weeks ago, and somebody told a story. They were talking about choosing agents and how the mom had chosen daughter to be the healthcare agent, but chosen her son to be power of attorney agent. So that as mom became disabled, and she ended up with dementia and memory issues, so there was an extended period of time where decisions needed to be made and things needed to be paid for on her behalf. And in this family, there was friction between the daughter, who would work with the providers and figure out a good course of action for mom, and then the son would say, well, why is that important? And he would put everybody through explaining the thought process and doing everything again. He was sort of backseat driving the medical decisions with the money and acting very attentive to every cent that was spent. The observation was made during that panel discussion that perhaps this wasn't the best selection of agents, having the daughter in charge of the health care and son in charge of the financials. The feeling being that having those two different appointments, the daughter in one and the son in the other, created this conflict. My experience tells me, however, that it's unlikely that the appointment of them as different agents caused the conflict. It just gave it an open field to run with. So can I set it up so families get along? No. If the families don't get along, they're going to not get along. And you can't wave a magic wand and all of a sudden go, all the conflict that we've sort of put up with in the family without saying anything about it's just going to go away when I get sick or when I die. It's just not the case. Here's a good question. Don't I have to use my kids as agents? My neighbor, my cousin, my sister, everybody I know used their kids as agents. What if my kids aren't really good candidates to be agents? They're just not. It's not that they're bad people. They're just not good at administrative tasks. They don't get along. They don't have the emotional temperament to do it. And the answer is you never have to use your kids as agents. It's up to you. Just the way that you don't ever have to distribute your property or your kids, you get to give it to whoever you want to. You get to pick whoever you want to be your personal representatives, whether that's under the power of attorney, whether that's in the healthcare directive or healthcare proxy. You don't have to pick them just because they're related to you. You need to pick the people that will do the best job for you at those individual tasks. I always come back to three considerations in selecting personal representatives, these agents, the power of attorney, healthcare, trustees, executors. First, trustworthy. These are folks that you feel really confident they're going to carry out your wishes to their best of their ability. That leads us to number two. Two, that they do have some ability, some bandwidth, some competency to be able to do what you're asking them to do. If they're lousy with finances, they're not going to do a good job as one of your financial agents. If they are emotionally incapable of making decisions when people are injured or have diminished capacity, they're going to do a lousy job as a healthcare agent for you. You got to pick people that have a basic ability to do it and also some bandwidth in their life to handle it. Third, which I think is just as important as numbers 1 and 2, third being that those agents that you choose have a willingness and an ability to reach out for help when they know they need it. That they won't just sort of shine it on and say, I can handle this. Just because I get in a car accident, it doesn't mean that my power of attorney agent suddenly has to be Warren Buffett and understand everything about complicated financial matters. Keep in mind, I always tell my clients, keep in mind that those folks that you choose for personal representatives have the same authority that you do to consult attorneys, to consult CPAs, to get tax advice, to get any sort of specialized advice that they would need to do a good job. So that whether that's tax preparing, financial advice, whether it's legal, they have the ability to hire attorneys to consult about your matters to make sure that they're carrying out your wishes to the best of their ability. So those three things: trust, trustworthiness, the ability to do the job in a basic way, and third, the willingness to ask for help if they get overwhelmed. One last question, number 10, and this is another question about probate, and this is sort of almost where we started, is my mom did a trust. Remember, the first question was my mom did a will. Why are we talking about probate? This is a similar question. My mom did a trust. Why are we doing probate? Why are we talking about probate? So this comes up when I meet with folks after somebody has passed away who has done some planning and done, let's say, a revocable living trust, maybe even an irrevocable trust may be part of their plan, but they've done trust planning. If you've been listening to the podcast, if you've been doing any research at all, you know that one of the objectives of doing a trust plan is avoiding that probate process, that administration through the courthouse. That's only if you fund it. Because remember, a trust plan doesn't make any of the work go away of a will plan. What it does is it changes when that work occurs. With a will plan, you set it up, you give your instructions. It's up to your executor to get everything in the estate, then follow your instructions and distribute. They can't do that until they get blessed by the probate court, until they say, okay, you're good to go. Remember that difference between nomination and appointment. With a trust plan, you take all that work that the executor does later. It doesn't go away magically. What you do is you say, I'm going to do it myself. So I'm going to build a trust. I'm going to get everything in the trust. That way, it's all covered under the authority of the trustee. The trustee has the authority from me, not from the court. That way, when I become disabled or when I die, it's all in the box. It's all in the bucket, the basket, whatever you want to call it. It's in the trust. And you've appointed the person, not nominated, but appointed the person, the trustee, who can run it. This makes that funding process, loading the things in the basket, putting the boxes in the wagon is the way I talk about it at the workshop very often. If you think of your revocable living trust as that little red wagon, it's making sure your house, your other assets are in the wagon so that they're loaded in, because what's not in the trust is not covered by the trust. When we do a trust plan, there's always a will, and the will says, hey, if you find something that's not in the trust when I die, go get it and put it in there. But to get it and put it in there, you've still got that probate process. So unfortunately, folks aren't perfect. It's just the fact of life. Even folks that do a really good job of funding trusts, sometimes there's an asset that's not in it at death. I've had folks who had a death benefit from a prior employment that they'd forgotten about that comes in their own name. I've had folks who passed away and then received money from a relative's, a cousin's estate who had no idea they had a trust, had no idea that they would die before the benefit got there from the estate. There's any number of reasons why things may not get in a trust, why new assets may pop up. It could be a settlement of a lawsuit. Maybe I'm killed in a wrongful death situation. That lawsuit pays to my estate. To get that into the trust, you have to probate the will. So having to probate a will doesn't necessarily mean that Aunt Edna didn't do a good job funding the trust. What it means is Aunt Edna did a great job in her plan because it also included a pour-over will that said if there's something that didn't get in there, I want you to go get it and put in there. So sometimes probate comes up. I'd say with trust plans, at least among my clients, about 95% of the time, that will never sees the light of day. But sometimes we have to do probate to activate a will so that we can get assets from the estate into the trust so everything follows the same rules. So that's it. That's 10 quick questions. Just wanted to run through today. If any of these questions brought up a bigger interest for you, take a look at the list of episodes that we've got in the podcast, because I've done deep dives on many of these topics in those, and those will be helpful to you. Also, I'd invite you to visit the website. My website is Let's Talk Estate Planning, just like the podcast, letstalkestateplanning.com. My office is in Georgia. If you are a Georgia resident and you want to have a conversation about your own planning, contact the office. I'm happy to consult with you and come up with an estate plan that makes things easier for your family going forward. If you are interested in attending a live estate planning workshop that's got a question and answer session built into it, they always do, check the website. You'll see the next event coming up on the website. You can also submit questions and check out our blog, because in addition to the podcast, I've got a long history of blogs where a topic that you have some interest in, there may be a deeper dive already in there. Just like today's questions, I'd be happy for you to submit questions, and we'll pick them up in the next episode of Question and Answers. My name's Jim Miskell. I am an attorney in the state of Georgia, and my dream is that everybody's got their estate planning done so that when grief, crisis, and transition occur, Folks aren't running around town trying to figure out how to do administrative things. They are spending time supporting each other. If you found this content valuable, hit like and subscribe. I'll look for you on the next episode. Thanks so much. Take care.